Alright, here we go, folks. What's today? The 141 on December 9th. Head over to Nikki Alvarez Souls. I looked at this once this morning. They put this on a Friday. See what the court's doing to me now. Oh. Go look my last name up. Go look my first name up. You guys can look at it too. Success. We got success. Alright. They still haven't fixed Patrick AI from that one. From the civil case. I couldn't get a jerk on. Alright. So we'll go with... I'll do this in, I guess I'll do it in two parts. What is the second one here? 149. Order denying defendant's motion for immediate appointment of successor counsel and request for ADA accommodations. Motion to recall capias and reinstate bond. Motion to request remote hearing. ADA accommodations to address outstanding capias. Lack of effective counsel and improper service. And directions of clerk and notice of next hearing. I guess I looked at this once. This will be kind of off the cuff because I just glanced at it. And we'll get into this later. Be hard to read. So in the Circuit Court of the 6th Judicial Circuit, read that at your own leisure. They just lump all this stuff together. This one shot, one kill kind of stuff. So yeah, order denying defendant's motion for immediate appointment of successor counsel. Request for ADA accommodations. So it says this cause came before the court and defendant's pro se motion for immediate appointment of successor counsel. And I'll get into this. There's so much to unpack here. I can go for hours about this. And which one is this? It's denying? Denying. And the second part I'll do is striking. And they strike it because I'm still under the tutelage or the care or the malfeasance, misfeasance, and nonfeasance of a bar card member. But all of a sudden I'm per se. So yeah, this cause came before the court on defendant's pro se motion for immediate appointment of successor counsel and request for ADA accommodations filed October 30th, 2024. The dichotomy and just the double speak with what they do here, it's unbelievable. Motion to recall capias and reinstate bond filed November 1st. Motion to request remote hearing. Address outstanding capias and effective counsel. Having reviewed the motion's record and applicable law, the court finds as follows. What time did they... Hold on, what time did they stamp this? It's illegible. I can't read that. 6 p.m. How is the clerk stamping stuff at 6 p.m.? They close at 5. They got banker's hours. 6 p.m. They're working overtime for me over there. Deny my rights. So yeah, defendant was charged by information with one count of battery of first-degree misdemeanor. Defendant's charge remains pending. Defendant has filed multiple motions with the most recent October 30th, November 1st, and November 18th analysis. Motion for immediate appointment of successor counsel and request for ADA accommodations. This is 6 pages. This is going to take some time. And I am going to miss a bunch of stuff, but I'll address it later. I don't think anybody in modern history has faced such persecution. It is outright denial of civil rights, constitutional rights that I have. I don't think anyone's ever lasted this long. I'm sure people have faced this, but they have not lasted as long as I have. And so defendant contends that she has had 12 court-appointed attorneys, all of whom have withdrawn, the most recent of which was Marie Louise Mabry, whose request to withdraw was granted on October 28th. Defendant notes that she has not been appointed successor counsel, resulting in her remaining unrepresented. Defendant also argues that she is permanently disabled and chronically homeless and without reliable transportation. Yet she has been denied accommodations under the Americans with Disabilities Act, despite repeated requests. Defendant requested this court appoint a new attorney. It'll allow her to attend all hearings via Zoom or telephonically to accommodate her disabilities. And then they go on to state the defendant does not have an unlimited right to counsel. I knew they were going to do this. I knew it. They will do anything to keep me from getting a fair trial, or even a semblance of a fair trial. A defendant has no right to manipulate his right for the purpose of delaying and disrupting the trial. Bone versus State. So they're saying I have manipulated my right for delaying. And we'll get into it later, that I'm demanding a speedy trial, and they don't understand it. So they're saying I manipulated my right for the purpose of delaying and disrupting. In some instances, a defendant who is abusive toward his attorney may forfeit his right to counsel. This is United States versus McLeod. This forfeiture is a loss of an attorney regardless of whether a defendant wants to relinquish his right. So they're saying I abused attorneys without any proof. No proof whatsoever. Not that they're conspiring with the courts in order to secure conviction. They're just going to say, hey, you did this. You abused attorneys. And now I forfeited my right to an attorney. And I don't get one, and there's no Nelson or Ferretta hearing. This is insanity. So yeah, the forfeiture is the loss of an attorney regardless of whether a defendant wants to relinquish this right. So yeah, I've been deemed a slave. Doesn't matter if I relinquish it, you're not getting an attorney. The court in Bowdoin also noted that the District Court of Appeals affirmed a court's refusal to appoint new counsel after defendants recalcitrance, antagonism, even personal attacks upon a long string of attorneys demonstrating his ability to allow himself to be represented. So they're saying all these conflicts of interest, and there was conflicts of interest, is what they claimed, without stating in the aggregate what those conflicts were. Irreconcilable differences. No one ever says recalcitrant. No one ever says it was antagonistic. There's no personal attacks, and they have no proof, but they're going to use this case law. So demonstrates the inability to allow himself to be represented by counsel. So similarly, the defendant has gone through a long series of attorneys throughout these proceedings, all of whom have withdrawn. Defendant has threatened several attorneys. This is a declaratory statement. Defendant has threatened several attorneys as well as recorded attorney conversations in court proceedings without consent. Where's the proof of this? Yes, I've recorded everything. Everything I could. The attorney prior to Miss Mabry provided testimony that the defendant made threats to her. Testimony with no evidence. And I have that testimony because I recorded it. She said she got an anonymous phone call. And I've told the courts about this. Everyone's getting anonymous phone calls. So they don't even put her name in. The attorney prior to Miss Mabry provided testimony. That would have been, I believe, the stripper lawyer. What the heck was her name? Jasenia Rosales. So provided testimony that the defendant made threats to her. And she recanted. And that's right, it's my legal playlist. I could make an elaborate video and show it, but it's in my legal playlist. She said she got an anonymous phone call saying I threatened her on a live stream. And the judge asked her, have you reported this to police? There's no police reports, no nothing. You can't go around threatening people and not making police reports about it. So no evidence of that. But there's testimony from this woman who's got a criminal record herself. The defendant was previously warned by the court in its order dated July 15, 2024 that should she continue to behave abusively or egregiously toward her next counsel, in this case, Ms. Mabry. So they're saying I was abusively and I treated her egregiously? To Miss Mabry? Miss Marie-Louise Mabry? I put up all the emails to her. It's the only way I communicated with her. Such actions could result in forfeiture to her right to counsel in the proceedings because defendant behavior has continued to cause the withdrawal of appointed counsel. Even after being warned, she's forfeited her right to counsel and shall proceed pro se. So they're trying to say that I'm incompetent and I can't even stand trial, and now they're forcing me to proceed pro se, and they're saying I'm being a crap bag to these attorneys with no proof. And I knew they were going to do this. Anything they can do to keep you from getting a trial or being defended. Defendant next argues that she should be permitted to appear by Zoom or telephone for all further hearings because she has a permanent disability and is chronically homeless with transportation issues. Defendant's points of Tennessee versus Lane for the proposition that she's entitled to reasonable accommodations to ensure the access to the courts. However, Tennessee versus Lane court discussed access to the courts and specific disabilities to include visual and hearing impairments, developmental disabilities, and physical disabilities. Tennessee versus Lane, here the defendant has not specified what her permanent disability is, such as requires accommodations. So they're talking about chronically homeless. If you look up the definition of chronically homeless, it's anyone with a permanent disability that has suffered homelessness for a year or more, or something close to that effect. It implies a disability. Defendant has not specified what her permanent disability is, such that it requires accommodations. You have the right, the Fourth and Fifth Amendment right, to be secure in your person, papers, effects, and property. That's protected health information. And they'll use it against you. If I gave them my disabilities, they're going to say you're incompetent. They'll use that against me. And I'm not going to self-incriminate. It's protected health information. This judge, this prosecutor, all these attorneys are not they're not my doctor. The defendant's not specified a permanent disability as such that requires accommodations. So say I put that in there. Say I give them files and files and files and files of my disabilities. And it's got to get published on there. They're not going to redact it. That's my personal protected health information. That's covered by HIPAA. As a general rule, a physical or mental impairment is not automatically a disability under ADA. Been disabled for years, for over a decade now. No proof, no nothing. Just like they're saying, I'm threatening attorneys. We're the cops. They've already sent them once. So yeah, as a general rule, a physical or mental impairment is not automatically a disability under ADA. I'm going to miss a ton of stuff here. This is a lot to take in, and then I got to address all this, and it gets worse because they're not going to let me address it. I don't know if it'll be in this video or the next one. Internal citations omitted. Why would you omit them? Defendant has not given any details about how she is permanently disabled, so that the court may determine whether the request for accommodation is appropriate. They don't consider anything. They just tossed all my motions. Every single one of them. They're not going to consider anything. Except kicking the can down the road and never give me a trial. The only details defendant has provided that she's chronically homeless and without reliable transportation. Once again, chronically homeless implies a serious disability. Neither of which is a disability under the ADA. Further, the defendant has previously appeared in court numerous times in the past and has not adequately explained why she is no longer able to do so. And I have. Absolutely have. But it's 3 years of this crap? 3 years? I got to show up for court on average. I've had like 30 pretrials. There's 150 docket entries. That's once a month for 3 years that I got to show up for court. Nobody's capable of doing that. And no one in their right mind would do that. These people are mentally ill. Based on the foregoing, defendant's motions denied. Boldface. Motion to recall capias and reinstate bond. Defendant alleges that a capias was issued for her failure to appear at a pretrial conference that was set by an attorney who withdrew without appearing. That would have been the last one that you failed, you will not even name. Defendant contends that she has no legal representation for months leading up to this hearing. Defendant argues that the court's failure to grant accommodations for her to appear by Zoom or telephone is a cause of her failure to appear, and therefore the court should withdraw the capias. Never mind that, but I was represented very poorly, inadequately, by an attorney that said she couldn't even argue them. any of my motions. However, as noted above, the defendant has yet to provide adequate information about her disability in order for the court to properly consider a request for accommodation. You know what? And you're not going to get them. They will never give me a trial. Ever, ever, ever. I have a constitutional right to be represented by competent and ethical legal counsel. You don't get that. I have the right to face my accusers. You don't get that. I have a right to a trial by jury. to be judged by a jury of my peers, which doesn't exist, but you don't get that either. So you haven't given them information like they're my doctor. It's none of their effing business. Further, this court has ordered the defendant to appear in person numerous times. She continues to fail to appear. As a result, the capias remains. So it's a Mexican standoff. So they're saying, I have to appear there. But if I appear there, they're going to bring me to jail. I'll never get a trial. So I'll just sit in jail until the same cops that have targeted me, a well-documented history of targeting for over a decade, I'm going to be remanded to their custody so that, they can kill me? Defendant also reiterates this motion in her request for appointment of counsel based on the reasoning above. This request shall be denied, boldface. Motion to request remote hearing, ADA accommodations to address outstanding capias, lack of effective counsel, and improper service. This is tiring. 3 years is hung over my head. Everything's denied. And this is only the first part, and I'm going to miss a ton of stuff here. I'm going to have to spend days forming motions, and they're not even going to let me do it. And I'm going to prove that here soon. In this motion, defendant alleges that her most recent attorney failed to address a capias issued against her. She notes that her previous attorney informed her via email that the capias was mentioned during a hearing, and the defendant was barred from attending. Next, she argues that her motions to recall the capias have all been ignored, such that it's uncertain whether the capias remains in effect. Defendant acknowledges that she believes that if she returns to Florida or appears in person, she will risk being arrested and held in jail indefinitely, based on the delays that have plagued this case thus far. She contends this would violate her rights, including the right to a speedy trial and effective assistance of counsel. As such, once again, defendant requests that the court recall the capias or reserve upon. It's not that I believe that if I return to Florida in person, I will risk being in jail. It's an absolute fact. I will end up in jail. I'll never get a trial. I'll be held indefinitely and potentially killed by the sheriff that's targeted me for a decade. Moving on, defendant requests ADA accommodations for a permanent disability. In quotations, like it doesn't exist. And there isn't a multitude of them. To appear remotely for hearings due to her living situation and hardship. It's not even about that anymore. It's about, it's been 3 years. I've moved on. I've moved out of state because of my targeting. Just like the sheriff deputies that sued the department under a RICO lawsuit have left the state, fearing for their lives. Because these people will off you. She states she is homeless, living in her vehicle, and that attending in person will require her to drive over 2,000 miles round trip, which is absolutely true. Defendant concedes that she has attended numerous court appearances throughout the case, but the continued delay in this case placed an undue burden upon her. It's been 3 years. You're saying I touched someone's shoulder. I show evidence that I'm the only person with documented injuries, and you're going to drag it on 3 years? And it won't be over for another 3 years, 6 years, 10 years. They'll never give me a trial, ever. They just want to throw me in jail. They probably want to take my life. I know they want to take my life. And that's that. Next, defendant claims that the court has continued to provide improper service of notices due to her eviction and homelessness. They're not denying I've been evicted. Defendant states she was constructively evicted from her residence due to a no-contact order imposed by the court and requests email communications for further notices. Lastly, defendant again echoes her request for appointment of counsel and a right to a speedy trial. The court has considered defendant's most recent motion and, as explained above, shall continue to deny her request for appointment of counsel. So you got a disabled person. It's a fact. I'm a disabled person. I'm a homeless person. It's a fact. I haven't been to law school. That's a fact. Gideon versus Wainwright. Supreme Court case law. But they're saying that doesn't apply to me because they're alleging that I abused attorneys without any evidence. None. Defendant requests her appear remotely for hearings because she once again fails to provide adequate information regarding her permanent disability other than references to homelessness. Homelessness is not a disability. Chronic homelessness is. Without additional details or proof of disability, it remains unclear whether the defendant has a defined disability under the ADA that would be appropriate for accommodations. Likewise, defendant requests to recall the capias shall be continued to deny as well. Everything's denied. Inasmuch as defendant challenges notices, this court has provided service to defendant for services of orders in accordance with Florida Rule of General Practice and Judicial Administration and Florida Rule of Criminal Procedure, whilst defendant was represented by counsel, such service was through the appointed counsel. However, during periods, this is where it gets muddy. And I don't know if this is going to be in this part or the next part. There's where they struck everything. They're saying I'm still represented. So they're considering some things, well, I'm not represented, and some things, well, I am represented, but I've not been represented because they quit a long time ago, such as the prior 11 or 12 attorneys that were drawn. This is disgusting. Likewise, defendant's request of the capia shall be denied as well, blah, blah, blah. So yeah, such service through appointed counsel, that I have counsel that will not talk to me, that isn't counsel. However, during periods where defendant was without counsel, once she is forfeited her right to counsel, the court served defendant at her designated email address. They have not. They have not served me. I had to wait. I saw this on Friday, and I had to go in and request it be unlocked. It's an unofficial document I have here, because they did not serve me, and they don't care. Further, it should be noted that it appears the defendant has not requested the clerk of court, which sends the most physical address. They want me to put a email designation. Enough of this. Just enough. Here it is right here. Here's another one. Moreover, it's unclear if defendant's mention of the speedy trial rule was an attempt to invoke her right to speedy trial. My motion was titled Demand for Speedy Trial. And I think like vacation or when all these attorneys, they waived my right to a speedy trial. So I demanded a speedy trial, and I asked that they undo all the waivers. So that it's unclear, even though it's a demand for a speedy trial. As addressed to this court, July 15th, as addressed in this court, July 15, 2024, the speedy trial rule is not self-executing. It requires the defendant to take affirmative action to avail him or herself to the remedies afforded on the rule based on the state's failure to comply with the time limitations. Florida Rule of Criminal Procedure provides the required procedure for a proper demand of speedy trial. The defendant's brief mention of the speedy trial rule does not reflect the defendant has taken the initial affirmative steps in order to properly assert a right to a speedy trial. It was a demand for a speedy trial. Nearly 1,000, it might be 1,000 days now. I want my trial. I couldn't be more clear. These people can't understand it. You're not going to get a trial there. You're not going to get a fair trial. You got this freaking bozo, King Judge Frank I. Gray the third or the second, just kicking the can down the road, just stepping all over my rights, and he's stepping all over everyone else's rights. Because they want to cover up for the fact that I've been targeted by the sheriff for a decade. It's indisputable. Defendant is again reminded that a demand for a speedy trial binds both defendant and the state and indicates a bona fide desire for the accused to be brought to trial. Yes, I want to be brought to trial. You won't give me an attorney. I'll have to do it myself. You haven't held Nelson or Ferretti hearings. I got to do a voir dire and go through these peremptory strikes and do all these interviews and cross-examinations. I'm a disabled person. I'm homeless. And if I go down there, if I attend any of this stuff, they're going to put me in jail. So the demand for speedy trial is a pleading by the accused that he or she is available for trial, has diligently invested the case, and is prepared or will be prepared for trial within 5 days. Yes, I am. I'm prepared. I'm as prepared as I'll ever be. And I stated that on the record as a fact that I want a speedy trial, even though that cannot exist. It's been 1,000 days. There's no such thing. But they deny it anyway. Defendant should lastly note that her in-person presence would be required to proceed for trial. But they'll cancel it. They'll just throw me in jail. But did they say it was denied? It is denied because it's part of the title. But they're unclear about that. Lastly, based on the exceptional circumstances in this case, these are exceptional circumstances. They're saying I touched the #1 champion MMA fighter on his shoulder, and I'm covered in bruises and bite marks, but this is exceptional circumstances. Defendant shall be advised that his court shall not address any further motions filed by her unless she schedules a hearing and appears in person in order to argue them. It's a Mexican standoff. The court will not address any further motions. and appear in person to be arrested and thrown in jail, remanded to the custody of these abusers known as the Pasco Sheriff's Office until they kill me. So they can fail to address them. I'm going to pepper them with motions. I'm going to address everything here, line by line by line. I'm going to continue to assert my rights. Because you can complain to the Judicial Qualifications Committee. You can call the governor. You can call anybody. They're going to let this guy run crazy. Accordingly, it's ordered in a judge that the defendant's motion for immediate appointment of successor counsel, request for ADA accommodations, motion to recall capiens and reinstate bond, and motion to request remote hearings, ADA accommodations to address outstanding capiens, lack of effective counsel, and improper service are hereby denied. So, what about my speedy trial? Was that denied? Defendant's motion for immediate appointment of successor counsel, ADA accommodations, KPS bond, remote hearing, outstanding KPS, lack of effective. All right, so they denied everything. They didn't deny my speedy trial, which would be on the 14th. That's 5 days from now, which I think would fall on a Saturday. But they're gonna fucking bulldoze right over that, and they're not gonna give me what I demanded, and it's gonna continue for 3, 6, 10, 20 years, the rest of my life. It's further ordered and judged that any future motion for the defendant wishes the court to address, the defendant shall schedule a hearing and appear in person to argue them. So drive 1,000 miles down there, get arrested, lose my van, lose my animals. No, absolutely not. You're on drugs. There is something seriously wrong with these people. Seriously wrong with them. I'm not showing up in person. I'm not going to go to court every month. Give me a trial. A jury trial. A trial by jury. They will not do it. And like I said, I've missed a bunch of shit here. There's a lot of minutia. I'll address it on paper, and I'll send it to them. I'll serve it to the courts. I'll document it here. And they're always saying that they're not going to do anything. They're not even going to look at them. They're not going to look at anything I do unless I show up. They're not going to give me... they're not going to give me legal representation as guaranteed by the 6th and 14th Amendment. You got due process clause. That doesn't apply to me because they said I threatened people without any proof of it. None whatsoever. It's not a court of law. They don't care about proof. Just do whatever they want. It's further that a pretrial conference will be held for the dishonorable Frank Graham, Monday, December 16th. So Saturday is 60 days after I demanded a speedy trial. And they had 50. Within 50. So yeah, there's no way I'm showing up. There's no way I'm showing up unrepresented with a warrant on me. Even if I didn't have a warrant, I'm not in a position to defend myself. Clearly. I could go on for 3, 4, 5, 6 hours, 3 years like these people do about this. But we'll move on to the second one where they strike everything. But so yeah, nothing applies to me. No constitutional rights, no civil rights, nothing. These people, they're going to deny me every step of the way at anything I do to never give me a trial. Ever. It's proven. It'll never happen.